ಹಾಲಿ ಸಿಎಂ ಅರ್ಜಿ ವಿಚಾರಣೆ ಮತ್ತೆ ಪುನರಾರಂಭ ಆಗಿದೆ. ಸಿಎಂ ಪರವಾಗಿ ಹಿರಿಯ ವಕೀಲ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ಅವರು ವಾದವನ್ನ ಮಂಡಿಸ್ತಾ ಇದ್ದಾರೆ. ರಾಜ್ಯಪಾಲರು ಜನರಿಂದ ಆಯ್ಕೆಯಾಗಿಲ್ಲ, ಅವರು ನೇಮಕಗೊಂಡಿದ್ದಾರೆ. ಹೀಗಾಗಿ ರಾಜ್ಯಪಾಲರಿಗೆ ಹೆಚ್ಚಿನ ಉತ್ತರದಾಯಿತ್ವ ಇದೆ. ರಾಷ್ಟ್ರಪತಿ ಆಳ್ವಿಕೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ತೀರ್ಪನ್ನ ಉಲ್ಲೇಖಿಸಿ ಸಿಂಘ್ವಿ ವಾದ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
This is very important for my case. Because I kindly don't want one thing. Your Lordship is dealing with a very weird case. Your Lordship is dealing with the converse of this of MP. MP, they rejected Mr. Sorabji on bias. And in my case, the only ground is bias. I don't want to overstate. Please don't. The only ground is only. In MP, they held irrationality. In my case, the governor doesn't address irrationality. Forget finding. That's as simple as that one. So they are actually mirror images of each other. There is also no authority for the proposition that a bias can be presumed in such a situation. My Lord Muda, I'm very grateful for the question, therefore. It's very important. The real doctrine of likelihood of bias would also not be applicable. So they said we'd applied. If we applied, we'd apply likelihood, not subconscious bias. And likelihood doesn't arise in this case, MP is what the court is saying. The decision was taken collectively by a responsible body in terms of its constitutional functions to repeat only in a case of apparent bias. Now, just pause here. Let us not go further in MP. How was MP cited by the other side and how was MP cited by the governor in his order? Was not MP cited in the order clearly as a case of presumptive bias?
It was.
I'm very grateful.
It's a matter of record.
It's a matter of record. I mean, it's not that we are saying something, the Lordships can't change the language, I can't change the language. This is exactly contrary to the case cited by the governor. This MP is saying no. And we are all reading it and saying yes. Thus, now I'm summarizing MP. I'll come to the other paras of MP very interestingly on the irrationality.
Irrationality. So the bias is over now.
Oh, yes. Thus, so well, because bias was actually what is argued by them also.
Yes, that is.
And by the governor's order, it is argued there. Therefore, it is important to get rid of this part first.
It refers to real likelihood of bias. So even that is not applicable.
Also very important query in the morning session. One, bias can be. Two, bias can't be presumptive. Three, bias has to be, if it arises in a case, likelihood of bias. Your Lordship knows very well what likelihood of bias is. Your Lordship deals with every case, well as Nemo Judex itself has well as all those sub rules, etc. And four, it must be shown, but I am asking myself one question at the top of page 19.
Yes.
The last two lines of 18 and 19 top, not identically my case. Should I be citing MP or should they be citing MP? I don't want to oversimplify or over-exaggerate. Just read those two lines. This is my case. Thus, the decision was taken collectively by a responsible body in terms of its constitutional functions. One sentence only. This is what happened here. But you said that a collective decision by a constitutional body is per se presumptively biased by misreading MP. Now, 11.1. The contention, take it out, the judgment. No, the judgment MP. The contention that the decision of the Council of Ministers was tainted was expressly rejected at para 24. The reliance placed on para 17 in the written submission of the opposite side.
Yes.
They adopt the error, Manas. They adopt the error. The decision is not an authority on the point of apparent bias, as the facts in that case did not concern prior approval or sanction of a chief minister. The Honorable Court thus made only a stray observation that in such cases, it may be possible to contend that there is an apparent bias. The next line says, but we are not called upon to decide that. Now, Manas. The decision of the court turned down 11.3, not on bias, but because there was an express finding that the decision of the council was ex facie irrational. This is 11.3. And because it failed to consider Lokayukt report, as my lord just pointed out, recommending registration of an offence which was relevant material. Please note paras 24 to 31. Now I'll just read this part, then I'll read those paras. Let me finish reading this part. I'm applying it immediately to my case.
Yes.
Applying this to my case, there must be overwhelming material based on which a prima facie case is clearly made out. And despite this, prior approval is refused. That's as simple as that. The cabinet says, don't give sanction. Material says to the contrary. The governor says, this is the material. You are wrong. Then your lordship will not grudge him the power. But he can't just walk in and apply an automatic presumptive test, fellows,
There the cabinet had fumbled in MP.
by not looking at this Lokayukt report.
Lokayukta report.
The observations at 32 of the MP sanction order of the governor dated 16/8 have nothing to do with bias and are rendered in the context of irrationality and arbitrariness, as is plain from the preceding paras 24 to 31. That's the judgment actually, which we have forgotten. We are going on bias. The judgment is not on bias at all. And you are not giving an order on irrationality. Then how are you relying on the judgment? In any event, in the facts of the present case, the order of prior approval does not contain any reason why the decision taken by the council was irrational. Nor is there any basis for such a finding. The governor does not record that there is a certain relevant material. You also put a simple question. Which material does the governor say that the council, Malus, of which I was a head not for that meeting, has missed out? Which Lokayukt report? Which report? It doesn't say so. Even assuming without considering there is apparent bias is a ground enabling, there exists no apparent bias in the present case, where the chief minister not only recused himself not attending the meeting nor participated in any deliberation. Given that there is no declaration of law in MP, forget the last para. Now I'll just read that MP for a minute. Which volume is this? It is
And
volume 2, Malus, case law volume 2, earlier one, relevant at page 339. The page at the bottom of the page. Not mark anything, while I'm arguing, judgment is problem. Give me the marked lines, give me blank things.
page 3.
Is the same volume? 2, yes, same. Huh? This is volume 2. Yes. So why is it 339?
No, there is no 339.
This 339 is changing here. Changing. Well, volume 4, 231.
Volume 4.
Yes, apparently the pages are not matching. Just giving it. No, which case is this? Which case are you showing?
339.
MP at 230 of, is it marked volume 4? Volume 4. Mark it volume 4. Mark it. This is the latest one. Why don't you mark it?
No, 230 is Nabam Rabia. Earlier to that.
Latest today's volume. Last volume.
Today's volume.
230 is Nabam Rabia?
Yes.
Mr.
This
Solis
is
Rabji has not
210,
placed-
210. In today's volume, MP Special Police is 210.
I'm on the relevant portion, 230.
2?
230 is the relevant portion.
Yes. 230.
So this para your lordship has seen, Malus,
Yes.
already. Mr.
Yes.
Solis Rabji not placed on record how, may I read this? Not placed on record how Council of Ministers, collectively or the members of the council, individually were in any manner whatsoever biased. There is also no authority for the proposition bias can be presumed in such a situation. The real doctrine of likelihood also not be applicable. Right, Malus? This your lordship is read with me.
Yes.
Now, on the same analogy, in the absence of any material brought on record, may not be possible to hold that the action on the part of the council was actuated by malice. So far as plea of malice is concerned, the same must be attributed personally against the person concerned and not collectively. But the whole council is malice.
Yes.
My whole council is malice attached in a uniform manner. Even in such a case, the person against whom malice on fact is alleged must be impleaded. However, here arises another question. There are two competing orders. Now, this is where the thing changes. One of the council, another by the governor, one refusing to grant sanction, another granting. The Council of Ministers refused to grant sanction on the premise that there existed no material to show that R4 in each appeal had committed an offence of conspiracy, where the governor in his order was clear of the view that materials did disclose. An FIR was lodged in relation to the commission of the offence. Now, Malaz, this is enough, I would say, for your lordship to send any matter back saying council is wrong.
Matter back?
Any matter your lordships can say the council is wrong if para 28 exists.
Yes.
Anybody would say it, Malaz. I'll not read it. How is it that the council ignored a Lokayukt report of such detail? It's as simple as that. And this case is being applied for the other point, for the bias point. This para 28 in my case applies in my favor. I hope.
Yes.
28 is omission of looking at Lokayukt. The omissions of looking at reports are by the governor in my case, today's case. What your lordship said there applies to the governor here. And we'll just see the report of the Lokayukt itself gives the material at the bottom of that page. Your Lordship is ignoring everything at the Council of Ministers, then why will Your Lordship not intervene with us? At the bottom of that page 230, the Lokayukt is quoted. The point is not that they are right or wrong. The point is they should have noticed it, dealt with it. They did not. And then 29, Malas, they say how high the Lokayukt office is.
No, 29, sir.
Yes.
Last 5 lines,
Yes.
30
30?
and 32.
Your Lordship is on 30?
30.
Yeah. May I read the last 5 lines? It is now
Last 5 lines of 29.
Yes.
And
Now, while
third-
settle that refusal to take consideration relevant factor acting on the basis of irrelevant exchanges not germane to the purpose would vitiate an administrative order. In this case, on the material disclosed by reward of Lokayukt, it could not have been concluded that no case was made out. This is their talk about the council.
Yes.
Now, it is well settled exercise of administrative power will stand vitiated. There is manifest error of record or the exercise of power is arbitrary. Similarly, if the power has been exercised in the non-consideration or non-application of mind to relevant factors, the exercise of the power will be considered manifestly erroneous.
Now 32.
We have, but just 31 for a minute also.
Yes, sir.
31. We have no hesitation to hold that decision was ex facie irrational. This is that manifestly irrational. This is about the council. Exactly these words apply to the governor with great respect. Whereas the decision of the governor was not. That's the competing thing your Lordship is looking at. Is your Lordship told after so many days of hearing which part of the governor's report tells you, which your Lordship is reviewing, that this part of the Council of Ministers has omitted this? It's as simple. Well, we can all argue all these things. Has your Lordship been answered that simple question by the governor? My Lord is not sitting as the reviewing authority of the council first. First comes the governor.
No, of the governor. Yes, correct.
In a situation of this
32,
nature,
32 is what the apex court
the
would.
facts of these cases, the governor cannot act in. There would be complete breakdown of the rule of law. Be open for governments to refuse. This is in the light of that he must act in his
Yes.
discretion because he finds that the Lokayukta is missing. Does it say, Malaz, that governor can act at his discretion after Shamsher Singh downwards without giving a single reason as to what is wrong with the report in which he is acting in his discretion?
So everything boils down to the fact that he is entitled to disagree. The disagreement, yes, should be recorded. What is irrational in the note in the cabinet decision should be recorded. And a decision should be
crux.
taken.
That's the crux.
That is all.
That's the crux.
Yes.
But Malaz, only with one caveat. Even the starting point should be a little cautious. You should not say that first thing is I can jump in. You must look at it cautiously in a harmonious manner and then say, look, I am not for a minute suggesting that your Lordship has a case like this, where he has not looked at Lokayukt. I am the governor, I point out Lokayukt, and your Lordship says, no, the council is right not to look at the Lokayukt and the governor is wrong. I can never say that. But it's very, well, nothing is not rocket science.
Yes,
It's very
so-
commonsensical. And this also gives the court proper basis for review. It gives the proper test for review also. But Malaz, it leads to the interesting conclusion that MP, in last sentence on MP Malaz, is either completely in my favor or completely not applicable on bias
Yes.
or completely misapplied by the governor.
That we'll see.
All these three things.
Yes,
Malaz.
the apex court holds it is not a judgment for real likelihood of bias as well. So,
Yeah, well,
yes.
they didn't go into it. They said that, but Malaz, that
So the
sentence
submission itself is negative.
negative. And Malaz, 1 second, I'm sorry to repeat. One of the reasons is negative. This is the last line of 18.
Yes.
That is the reason it's negative. They are saying, well, actually, they don't say it in one sentence, they say it in two different sentences. It is negative, as the Lordship says, because they are rejecting the doctrine of presumptive bias.
Yes.
That is the point.
Yes.
That is the take home as far as I am concerned.
Yes. Yes.
That doctrine of presumptive bias is rejected at bottom of 18 and top of 19.
Yes.
They are
Yes.
saying it amounts to this, that you are saying per se there is a cabinet, there is a governor, and there is a chief minister, therefore out you go. Now, let us page 21. Now, this is the heart of the matter. As I said in the beginning, this is by itself sufficient ground to quash it. Just see the actual exercise of power. Now, I am assuming for the minute they're in exceptional. I am never agreeing, Malus, that in the walk-in, walk-out manner. The next page, 2010-9 SCC, where the summary I have reproduced with 2 or 3 underlinings at page 24 of my note. In India, the judicial trend has always been to record reasons, even in administrative decisions, if such decisions affect anyone prejudicially. And D, recording of reasons also operates as a valid restraint on any possible arbitrary exercise of judicial or quasi-judicial or even administrative power. And then, Malas, it's a very long list and it's a useful list. So I've read, Malas, A and D. And then read L also for London. Malas. L. Reasons in support of decisions must be cogent, clear, and succinct. A pretense of reasons or rubber stamp reasons. This is another very interesting passage. Had your lordship got the formality of reasons, your lordship is not obliged to accept it. Your lordship is not looking at rubber stamp procedures. Is not to be equated with a valid decision-making process, but your lordship is fortunately at a one stage anterior. There are no reasons to this issue. The reason is why I am not bound. That's all, nothing else. Chairman Mullahs of Kakkar's case at page 26. Now this passage I picked up because one of this ratiocination is very well defined in this para, rather well put. Come to page 26, fourth line, fifth line. Reasons are live links between the mind of the decision taker to the controversy in question and the decision or conclusion arrived at. Reasons substitute subjectivity by objectivity. The emphasis on recording reasons is that if the decision reveals the inscrutable face of the sphinx, it can, by its silence, render it virtually impossible for the courts to perform their appellate function or exercise the power of judicial review in adjudging the validity of the decision. How much more will it apply than in this case? Well, I throw a bunch of 1,000 pages at your lordship and say, look, my order is 5 pages. I don't address it, but you'll find something there. And then your lordship looks there, finds a comparative chart. Directly this para, I would say, well, I may be wrong, applies to my case. Right to reason is an indispensable part of a sound judicial system. Another rationale is that the affected party can know why the decision has gone against him. All these are reasons, fellows, why it has gone against him. One of the salutary requirements of natural justice is spelling out the reasons for the order made. In other words, speaking out. Speaking judge, a speaking out. The inscrutable face is ordinarily incongruous with a judicial or quasi-judicial performance. Although the governor is no doubt a high constitutional functionary, this is my submission. The very nature of the power being exercised in this case, the fact that it's an exceptional power, as he is ordinarily to be bound by the advice of the council, would suggest that the exercise must be accompanied by reasons. The governor's impugned order instead presents the inscrutable face of the sphinx, and it is impossible to discern from what factors it has arrived at and weighed with disregarding. Now, as your lordship decided Sri Rupa for 17A, yes. I don't think Sri Rupa means what has been said to your lordship it means. It is very clear what it means to me, and I have tried to explain that at 27. 17A casts an obligation of application of mind on the part of, just pause here, Malos. Forget 17, 19, 80, whatever, 287, etc. The concept is basically your lordship should be satisfied of substantive application of mind. Otherwise, your lordship is not allowing shadow boxing by saying this is little less, this is little more. Substantively. The section makes it clear that no officer shall conduct any inquiry without previous approval. Therefore, the approving authority will have to look into the materials, apply its minds in each of the 3 contingencies, inquiry or investigation. This should go someday. This E and I difference is very, very difficult. And it's, well, sometimes it really becomes a technical one. They should use a different word in the CRPC and this thing. You're all arguing about inquiry all the time. Though inquiry and inquiry are often used interchangeably, there exists a difference between the two. Etymologically, the source of both inquiry and inquiry could be the same, as EN is derived from French and IN is from Latin. Inquiry has a formal and official ring to it. Inquiry is informal and can be unofficial. Inquiry would even mean a question to question. Inquiry is a formal investigation. Investigation is search. Now I'm reading the underlined portion. Therefore, the Act casts an obligation of application of mind upon the authority to consider whether approval is sought for an inquiry, or an investigation. It becomes imperative for the authority to apply its mind to what is brought before it, as application of mind is the bedrock of any order that an authority possesses. Failing it should be contrary to the principle of natural justice, as non-application of mind is itself violation of the principle of natural justice. And there is no answer to this to say, my order be damned. The application of mind is in the interstices of the mass of 1,000 pages which I have in my office. That's the crux of it. That's the only thing they are falling back on. And that is, a travesty of how I will appeal, how I will react, how I will deal with the order, how your lordship will review it. It's only, a desperate attempt to justify it because they have not done it. So now they've come up with this thing about, papers in the office. Application of mind by an authority is demonstrable. Mark the word demonstrable. Only in the order that the authority makes. Now I'm asking myself, what are we talking about, Balus? This is my Lord's judgment which was cited against me. What is my lord? I can get, I was not aware, well, I'm not there in the matter. I have not checked the facts of Shirupa. I can guarantee that Shirupa could not have been a case of a 5-page order with a 1,000-page file. It must have been a better
There was
case.
nothing, there was nothing in the file, nothing in the order.
Now, Malas, application
Because
of
file
mind.
was summoned.
No,
there
but
were-
your lordship puts it very clearly.
Yes.
According to me, Malas, the lordship has to have black and white, which is what your lordship has done here. See the first line. Cited against me. That's the irony of it. Is demonstrable only in the order that the authority makes. My humble and respectful service, that's the correct view, Malas. We are not playing Malas games here. For the order to demonstrate application of mind, it must contain the reasons. So your lordship goes further. First is what is on the order, not what is in my almirah. Second is the reasons in that. As recording of reason and order is the only way that can construe such application of mind. Then your lordship gives this very felicity. That's why I quoted the Supreme Court first. Reasons are the links between the mind of decision taker to the controversy and the decision arrived at. Ratiocination, I call it.
Yes.
Reason and application are impregnable. That's a new word, Malas. Ratiocination, impregnable. No, because this is important, Malas. This is how administrative law is built
it
up.
is inseparable.
Public law builds up like this only, Malas.
It is inseparable.
For an order to sustain the scrutiny of law, be it administrative or quasi, reasons in every circumstance need not be elaborate, no problem. Nevertheless, should bear application of mind. The case at hand and the order impugned will have to be tested on the anvil of the matter statute, the intent and the rule of application of mind. If on a coalesce of all the facts that are narrated herein above and the order that is impugned on the anvil of this object and reasons, it would fall foul of the same as the order. Now, let's kindly bear with me here. As the order, except saying there is nothing indicative of the fact that it bears application of mind. Granting approval for setting the criminal law in motion cannot be a frolicsome act as is done by the state in the case at hand, as it does not even bear any semblance of application of mind. As this frolicsome should also be adopted by some other courts.
Playful act.
I go for my frolic of my own. This used to be used in those Malas, public servant cases, where it's within the discharge of your duty. So he used to say that in the English cases, Malas, he went on a frolic of his own. So
That's the...
now, Malas, I just pause here. This, my case, is actually in a way a better example against them. In a way, it sounds like a better example against me, but no. Your lordship, this case had possibly no reasons. I've not examined the order.
No reasons at all.
In my case, there are all reasons, but for one issue. And 15th of July, the governor himself had drawn the attention of the chief secretary. Now, this is very interesting, Wallace. He says, I have read of a commission inquiry set up by you that itself makes it clear that there is a scam and therefore I give sanction. See the next sentence. The same governor on 5th of July and 15th of July drew the attention of the chief secretary to the matter of alleged site allotment scam at Muda and requested the government to look into the matter and submit a detailed report. Just pause. Suppose the chief secretary had said, sorry, Mr. Governor, I will not have a report to you because you will use the report as an admission of somebody's guilt. Suppose the chief secretary had said so. The chief secretary would have a huge controversy on his hands. So as he has an inquiry, that inquiry becomes a noose around the neck to say, I am now finding culpability. But in both the actions of the chief secretary and the governor, there is no mention of the chief minister role. CM's role, zero. This is despite the fact that, I'm sorry, it states that even after such grave allegations being involved in the present matter and the fact that the materials prima facie support, therefore, now this is the total reason. What is the reason I'll find here, Malas? This is the total reason. Please read it for yourself, Malas, 21.2. Even after such grave allegations being involved, so allegations become a basis of conclusion. And the fact prima facie supports the allegation, therefore the decision taken is irrational. Here again, Malas, he is not giving you any single reason. And most important, the role of my client, the petitioner. I'm myself putting everything which is there against me. The said statement is entirely unreasoned and opaque, especially since all material is fully considered. Then 21.3. The order further says that since the prior approval is sought against the chief minister in the cabinet resolution, therefore it would not inspire confidence to act on the aid and advice. In support of this view, the governor refers to para 32. Now, I have done this fully. Leave it to yourself, your lordship's to consider, is it a fair understanding of MP? the nuance which I pointed out, the meaning of 32, nothing, brothers. Finally, the governor notes that there are two versions in relation to the same facts and therefore a neutral, objective and non-partisan investigation. This is very interesting. The two versions test is plainly an insufficient basis on which to disregard the errant advice of the cabinet. As in every case where the cabinet declines prior approval, there would necessarily be two versions, as my lord rightly put it, 3, 4 or 5 versions also. Truth has many facets.
Of course.
That is the old saying. What is that Sanskrit saying? Forgetting. It's in Hinduism especially, we say that the path to truth. In other religions, maybe one or two. But we have multiple paths to truth. So therefore, bhakti yoga or karma yoga.
Yes, yes.
So the truth must have many facets. Here are talking only of two facets. It was for the governor to point out some manifest irrationality in the version as outlined by the cabinet failed to do. Instead, he treated the complainant's version, a complainant of dubious antecedents, as at par with the considered view of the cabinet after seeking opinion of the advocate general and decided there were two versions. A neutral inquiry or investigation was called for. This supplies the fallacious test of why not the correct test of why.
Yes.
And if your lordship takes this test, then there is no reason required at all. Further, it is evident from the written submissions filed by the R2 that the decision of 1-8 was placed before the governor on 6th of August. Now kindly see this follows sequence in para 22. The governor asked that it be put up before him along with the comparative statements, the chief minister's reply and the cabinet decision. It is then stated that upon reviewing the file along with such comparative statements, certain notes, analysis and points were dictated. I'll put that dictated in inverted commas based on the comparative statement in the documents. On 16th of August, the file was once again put up before the governor along with the dictated notes. It is at that stage that the governor made the impugned order. It is relevant. Now this is one of the bullets. None of the materials placed in this para so-and-so have been placed on record by way of an affidavit. More important. Further and most significantly, if there were notes or analysis points that had been dictated by the governor, it is inexplicable why such analysis would be excluded from the impugned order. Well, my 22.2, I may be wrong, is my most important para on this topic. 22.2. Well, it is never, you dictate a long order in the file and you pass a 6-page order on bias only. Moreover and crucially, while the written submission of the respondent rely heavily on the file notings culminating in the impugned order, the impugned order itself makes no reference to such file notings or the comparative charts, tables, or the notes and analysis which have been dictated and with which the file had again been put up for the governor's approval. If these were indeed the factors that had weighed with the governor would certainly have said that in view of what is set out at flag X or flag Y of the file, it should be Y, not X. He accords sanction, approval. Thus, this is not a case where the impugned order of the governor endorses, accepts or ingrats into itself a previous file noting. Where the order itself does not do so, it is not open to the respondent to portray the decision as if it is based on such notings. The impugned order refers to the governor having perused the file and to the allegations and having independently submitted a report of the same. There is no reference of the charts or the notes or the analysis in the file. The petitioner had submitted a detailed reply, that is my reply, on 3rd of August, raising several legal and factual issues for the consideration of the governor. Apart from meeting point by point the allegations made against me, however, there is not even a whisper with regard to my reply and its consideration, either in the impugned order or in the file notings. The impugned order does not assign a single reason as to why the prior approval is being granted. No reasons as to why the detailed reply is not being accepted. No reasons as to how the petition complaint allegations make out a prima facie case against me. Very importantly, no reasons as to what role of the petitioner, while acting as a public servant in discharge of his duties at any stage, in the detailed factual background, is made known either in the impugned order, the file notings, or in the statement of objects or during the course of arguments. This goes to the root of the matter. Then was 22.5, reasons ought to have been assigned, etc. Both the paradigm reasons. Now, I'm just dealing with 3 aspects of 17A, which is that number 1 aspect is that your lordships does not equate it to Lalita Kumari. Second aspect is the police officer being the first filter.
Yes.
And third aspect is the impugned order is ultra vires 17A also and 218 also. these three aspects I'm now dealing with. One after the
218
other.
comes at a later stage.
Later stage. Correct. Now I'll kindly come to this. Two and eight was largely conceded, but I'll just deal with it. I'll come later. Just come to 32 minutes.
Page 32.
Yes, page 32, para 23. The power to grant previous approval is not to be exercised in a manner analogous to the test for registration of an FIR. The submissions proceed on the fundamental erroneous premise that the principles set out in Lalita are relevant for ascertaining the scope of the inquiry. The analogy seeks to draw between registration of an FIR and a grant of approval to inquire or investigate is misdirected, also oblivious of the legislative history behind the introduction. Nonetheless, this I am not going to go in detail, but I must let your Lordship know that the intent could not have been a FIR level inquiry. That's all. I'm just giving your Lordship, if whatever is worth is not dealt with by any judgment, it may help your Lordship.
In fact, the genesis of why this amendment had to come about sprang only from Lalita Kumar in 2014. The first law commission, I think, is in 2014.
Well, I've dealt with part of that.
And then it took 4 years to come about. Because approval was sought to be given to the hands of Lokpal and Lokayukta
and then
for approval.
And that was a much higher scrutiny. Only the person was changed.
Competent authority comes in.
That's all. But the degree, that's my core point. The degree was not reduced is my submission. That's the only point. Your Lordship will summarize it now. The initial idea was a proper filter and safeguard. That remained the idea. The power was taken from him and given to me.
Yes, it was initially envisaged to be given to Lokayukta or Lokpal.
He is the Lokayukta, I am the authority. It came
now
to
it
me.
is to the competent authority.
But in that process of transfer from him to me, the diminishing of the power to the extent it did not happen.
No, the provision remained the same, or the idea remained the same.
So
it is only the person who grants approval.
I am very grateful.
Change.
That's the crux of my submission. The idea is my point.
Whatever protective
idea
filter,
remained the same.
Protective filter that was envisaged in 2014 remained the same.
And the degree and quantum of that remained the same. The person exercising it changed.
It took 4 years to come into this form.
That because all these committees and
Yes,
back and forth.
yes.
Well, there's a delightful phrase for committees. One is a wag. Your Lordship, pardon me. It is not meant for any committee. But well, a wag generally commented that a committee is usually a group of the unfit, appointed by the unwilling to do the unnecessary. So whereas these delays happen because you want to also take off the time. Well, it's 24.1. The Prevention of Corruption Amendment Bill was introduced, did not contain any 17A. Then 24.2. It was first considered by the Rajya Sabha Standing Committee in its 69th report.
No, all that I'll go through.
Then, I'm not reading it.
Yes.
Then it was brought in 24.3. Then that bill went to the Law Commission.
Yes.
In February 2015. Now, this just see the middle, Malas. It is clear that the previous approval will be granted by Lokpal or Lokayukt and would be conveyed by an order under Chapter 7. Now, this Chapter 7 outlines the procedure for a robust and elaborate procedure, including calling for explanation. Therefore, from a mere perusal, it is clear that it is my submission. From very inception, the amendment proposing 17A as an additional entry checkpoint protective filter, was contemplated as substantive protection and nowhere close to the standard for registration of FIR. That's my proposition, but that's for Lordship's consideration. Then went to select committee, skip that, come to 25. I'm sorry, 24.5 is very important. I'm very sorry. The select committee proposed a further amendment where the power to grant approval was given to the appropriate government and not to the Lokpal. Thus, a change was made as to who would exercise this power. But it is clear the intent was always that the protective filter would be a substantive protection. But also, it's very clear, Manas, I happened to chair this committee in 2011 when the Lokpal bill was passed. Well, we piloted the Lokpal bill.
Yes.
Now, the Lokpal delay is inevitable. That was the main reason for this transfer actually.
Yes, yes.
Because the Lordship will give it to the Lokpal and give it to a competent authority. It's a vast difference of time. That's all. It is not that you are making the power less. It is just that you make it faster. That's really the bottom line thing. But anyway, this unfortunately not decided by any case. Then Malus, Shirupa at page 34. However,
that's a coordinate bench judgment where 17 and 19 are considered differently, and it is said that 17 need not bear that much of an application of mind like 19. There's a
Right.
coordinate bench judgment.
Right, right. So therefore, my lord,
Which distinguishes the judgment that I had rendered.
but my lord, I am relying on your lordship's judgment. I am
Yes,
not
yes.
distinguishing it.
Yes.
I am adding to it with
Yes.
this para and underlining what I'm relying on this one also.
Yes.
I have no contradiction in my mind. Madam. They have the ones who argued, may have argued differently. But they thought that Shirupa is against me. I demonstrated that part of Shirupa, Lordship's judge. Now, this one, just see what I'm relying on.
Yes.
Middle of page 34. In a sense, a public servant is placed on a pedestal and treated differently as compared to a citizen against whom an allegation of an offense is thrown. The law thus grants an extraordinary layer of protection.
Hmm.
This is the idea.
Yes.
Then 35. I'm not trying to avoid anything. I've quoted it, but I'm just reading
Yes,
faster
yes.
too. Has some credible evidence on the basis of which he forms an opinion that an investigation is warranted. Who is he, Malas? This he here is the police officer. This he at 35, credible evidence on the basis of which he forms an opinion that an investigation is warranted.
Police officer is what you are trying to say. Yes.
Then, Malas. No, the whole para, just give me a minute. Let's come to para 30 at page 34 bottom.
Yes.
It is therefore not necessary there should be a clear incriminating evidence with the IO.
At the stage of him seeking
At the
approval
stage of him
under
seeking
17.
prior, all that is required in the provision of the Act is that the IO has some credible evidence on the basis of which he forms an opinion. This part is clearly IO, Manas. He gives me the information, I am the IO, I form an opinion, then I seek approval. There are 4 steps or 3 steps. Information, formation of opinion, seeking of approval. As a consequence, the state government would be required to only consider the opinion that is formed by the investigating officer. Why is the Lordship saying all this? And the material that he possesses while considering the request for approval. Since the public servant is yet to be investigated, the question of considering an India, I'll skip that. 34, next para. It is also clear from the wording of section 17A. The state government is not required to exhaustively and meticulously consider all the material available with the investigating officer at the time he seeks approval. It is only required to
This is
examine.
where it is different from what I have said.
Correct.
It need not apply its mind is what is said here.
Well, it's, I see the difference in emphasis, but I don't think it would be right to say that your lordships is wrong in saying application of mind. That would be, well, say, something which will possibly not stand the test of law, is my submission. And this, even though it's worded differently, should not be read to mean that application of mind is so diminished as to be a formal administrative entry in the register.
Yes, that is true.
That is the way I would look at it, because
ಇದು ಏಷ್ಯಾನೆಟ್ ನ್ಯೂಸ್ ನೆಟ್ವರ್ಕ್ ಪ್ರಸ್ತುತಿ.
ನೀವು ನೋಡ್ತಿದ್ದೀರಾ ಏಷ್ಯಾನೆಟ್ ಸುವರ್ಣ ನ್ಯೂಸ್.